We've given it a couple of minutes and it's just past 10, conscious that you'll all have busy days to be getting to. So I think we should get started. This is being recorded and it will be distributed to everyone who signed up. So even if you do join late, whilst you won't be here to hear that explanation, you will receive it in due course. Firstly, good morning. My name is Ian Cooper. I am a member of the business and property team at King's Chambers 2019 call. I have still a fairly broad chancery practice and general commercial practice. As you'll see from the title slide, this is the latest in the King's Young Professionals series. I'm going to be talking about contractual rights to recover costs. Now, the eagle-eyed among you will spot I've put right, I've italicized right, and there's a question mark at the end. As we'll come to see, it isn't necessarily a guaranteed watertight enforceable right. And one of the most important things to be recognizing in all of this is the importance and the continuing existence of the court's discretion. This isn't something that you simply get the court to rubber stamp. I'll have to thank ChatGPT for the image. It wasn't, unsurprisingly, that easy to find a cartoon dealing with CPR rule 44.5, but ChatGPT was able to fill that gap for me. So let's begin. I'll hopefully be done before 10:30 or thereabouts. If there are any questions arising, do pop them in the chat as they go through. If we have time, we can deal with them at the end. If we don't, then you can always pick those up with me offline. So firstly, why am I talking about CPR rule 44.5 and a contractual right to recover costs? Well, costs is always, the first point really is cost is always a topic that gets everyone animated. It's something that all parties have an incentive in wanting to try and maximise their recovery in respect of. King's Chambers have a specialist costs team, but the point is you wouldn't be instructing costs specialists to deal with a contractual indemnity. It's not really something that would justify the instruction of specialist counsel. This point is an important one, but it's something that you need to be aware of the principles of yourself, because they present themselves at the very beginning, as we'll come to see, of proceedings when you're thinking about pleadings. And there really are, putting that to one side, two particular reasons I think that this topic is apposite for a King's Young Professional series. The first is, in small value claims, costs and the recovery of costs can be particularly important. If anything, the importance is heightened in circumstances where you might be dealing with a claim on the small claims track or a low value fast track claim. And so being aware of the rules on contractual recovery of costs is particularly important in that context where you're trying to escape the possible constriction of fixed costs regimes. The second point is that knowing the rules and knowing how to explain the rules to the bench, I think, is a particularly sensitive and important area. There have been a couple of, just from my personal experience, some of the worst instances of judicial treatment I've had where judges have been really quite hard to me as an advocate have been in instances where I've been looking to enforce contractual rights to recover costs. And that's because judges don't like the suggestion that their discretion is in some way fettered or is being interfered with when it comes to costs. And so I think it's a point that needs to be handled delicately. It needs to be handled forcefully because it's an important point to be making to the bench, but it needs to be handled sensitively and delicately. So with that explanation in mind, I'll come to look at the rules. Now, I've referenced already Rule 44.5. It's set out on the slide. And what it says is that subject to subparagraphs 2 and 3, if a contract assesses, where the court assesses whether by detailed or summary assessment, costs which are payable by the paying party to the receiving party under the terms of a contract. The costs payable under those terms are, unless the contract expressly provides otherwise, to be presumed to be costs which have been reasonably incurred and are reasonable in amount, and the court will assess them accordingly. And then that rule is subject to sub-rules 2 and 3. 2 says that the presumption in paragraph 1 is rebuttable, and paragraph 3 says that paragraph 1 doesn't apply when you're dealing with contracts between solicitors and clients, where, as we'll be aware, there are specific rules regarding costs recovery. So just pausing at this first juncture, ultimately, Rule 44.5 is a presumption. That's what it's setting out when the court is dealing with assessment. So not with the principle of costs, where the court's discretion, as we're going to come to look at, remains front and centre. But what Rule 44.5 is saying is once the court's decided the principle of costs, when it comes to assess costs, there is a presumption that costs have been reasonably incurred and are reasonable in amount, and that presumption can be rebutted. So the rule doesn't take you any further than a presumption. You need to understand the underlying general principles about these contractual indemnities. Now, the next slide sets out part of Practice Direction 44. It is paragraph 7 of Practice Direction 44, which if you're dealing with a small claims track hearing or a claim in the possession list or a mortgage claim, then you want to be aware of the original source of the rules. And so you want to be able to take the court also to paragraph 7, Practice Direction 44, which sets out that rule, that presumption we've looked at, only applies when the court's assessing costs. And it doesn't the court's hand isn't being forced in any way, doesn't require the court to make an assessment of costs. And then it's also the sub-rule, so paragraph B, touches on the rights of mortgagees. And I haven't set out the remainder of paragraph 7 of the Practice Direction. You can look it up separately, but it elaborates upon the principles applicable in the mortgage context specifically. And that, when you're thinking about contractual indemnities, it is the two areas where this crops up most often are firstly in the mortgage context, and secondly in the landlord and tenant context. On the next slide, I've set out the 3 key cases which you'll always want to be having reference to if you're looking to argue this point. And the first case that all of this stems from is a 1992 case, which was in the mortgage context. So that case that is at the top of the slide, Gomba Holdings, in that case, the court summarized the principles which are applicable. It called it taxation as opposed to assessment, but they were talking about the assessment of costs of a mortgagee looking to recover from the mortgagors in quite a complicated group debenture scenario. But ultimately, it synthesizes 5 principles, and some of them aren't applicable in the wider context. They deal with the equity of redemption, and they talk about the fusion between courts of common law and equity, which is all specific to mortgages. So I'm not going to talk about mortgages specifically. This isn't a mortgage-specific seminar, but that's where the rules came from originally, and they were then extended in that second case on the slide, the Church Commissioners for England v. Ibrahim, into the landlord and tenant context as well, because these clauses, these contractual indemnities, it will be worded in different ways in different contracts, will often be included in landlord and tenant contracts. You'll have seen these when dealing with either possession claims or forfeiture claims. And that is another area where these clauses commonly crop up. What I would say is if you're dealing with the mortgage-specific context, have a look at the commentary to Rule 44.5. that sets out the principles which were summarized in Gomber Holdings. Now, the headline, just in case it is of interest to anyone who's got a mortgage contact case going on at the moment, and as you'll probably know already, is that mortgagees are allowed to reimburse themselves out of the mortgage property for all the costs, charges, and expenses reasonably and properly incurred in enforcing and preserving their security. And it's for that reason that when you're dealing with a mortgage possession claim, the mortgagee, the bank will often, the charge holder, often want the order to simply be silent as to costs, because they can rely on those contractual entitlements and the general entitlement to recover their costs. So putting where the rules came from to one side, what are the rules? The general principle and the key point to take away is that even if the parties, the claimant and the defendant, have agreed between themselves that, for example, the defendant tenant will pay all reasonable costs incurred by the landlord, that does not bind the court's discretion. An order from the court for the payment of costs, deciding the principle of costs, who pays, is always an exercise of the court's discretion. That is set out in Section 51 of the SCA, the Senior Courts Act 1981, and is reflected under the rules regarding costs, under Part 44. So at no stage does the contractual agreement tie the court's hands. But, and this comes from that first case, the Gomber Holdings case, where there is a contractual entitlement to costs, the court recognises, this has been recognised at the Court of Appeal level, and that third case, Chapler and Kamari, at the top of the slide, is a helpful one because it synthesises the principles in a slightly shorter and more succinct judgment than the Gomber Holdings case. So if you're ever wanting to take an authority along, Chapler is a good one to take. What the court and the Court of Appeal has recognised is when the court's exercising its discretion, the fact that there is a contractual entitlement is a very significant factor. And the way that it's worded in Gomber is that the discretion should ordinarily be exercised to reflect that contractual right. The question, of course, arises, well, when will it not be exercised? What are the kind of instances when the court might be minded to not to award costs in accordance with the contractual entitlement? And what Gomber says is that the court will be concerned when there might be a suggestion of wasted costs. So if there's been any improper, unreasonable, or negligent, either act or omission on the part of a party or a litigant or their legal representative, then that is the kind of instance where if you are the paying party and you're saying, no, we court don't want you to order that there be a recovery in accordance with the contractual entitlement, you'll want that is the kind of thing to be pointing towards. It's the wasted costs jurisdiction. And we'll also, I'm sure, on this call know that wasted cost jurisdiction is a fairly exceptional jurisdiction. So what that means is that actually it's quite difficult to argue in theory against this contractual entitlement. I say that when you look at the authorities. In practice, I find that judges are often not receptive to an argument about contractual entitlements. I've alluded already to the kind of reception that submission can be met with. And that's because it goes back to the court not wanting to feel as though its discretion is being fettered or interfered with in any way. Now, the third principle I've got on the slide is that it's always there's a question of contractual interpretation. So it's all well and good saying that you've got a contractual indemnity, contractual right to recover your costs. But what you need to satisfy the court of is the fact that contractual entitlement is engaged on the facts. And that will always be a fact-specific assessment. Now, I've put on the slide a slight warning. There's a reference to a recent Court of Appeal decision, the Ken Square decision in 21, what happened, or what that citation is a reference to, is in fact a reference to another. It's a land tribunal, a land chambers of tribunal decision, where the judge in the case being referenced, Sinclair Garden Investments and Avon Estates London Limited, the Judge Bridge said, and this is a reminder of a principle we'll all be familiar with, but it's just worth reiterating, which is that each case is fact specific, in the sense that what must be construed is the particular clause in the particular lease of the particular property, and conclusions arrived at by previous courts or tribunals in relation to other clauses in other leases of other property are unlikely to be of much assistance. That's just a reminder that when you're looking to say that your clause is engaged, make sure that you engage with the specific wording of your clause. If it includes wordings to the effect of A is entitled to recover all costs and expenses incurred from B in pursuit of litigation, as an example, that's a very broad wording. And you would hope to have a compelling case to a judge that clause has been engaged. But that doesn't avoid the need to satisfy the court that the clause is engaged. So turning over to the next slide. Excuse me, I'll just have a sip of water. I put on this slide a couple of examples of wording of contractual wording which has been considered. Now, you might criticize me for ignoring the health warning I've just set out, which is, you've always got to interpret the specific clause. Of course you do, and I'm not going to suggest otherwise. It is helpful to have reference and consider what approach has been taken in other cases. Now, the important point that you're going to be wanting to think about is, well, if I've cleared the hurdle of satisfying the court that my clause is engaged, what's the basis of my assessment? Rule 44.3 sets out the two bases of assessment that there can be. We'll note standard basis or indemnity basis. That first case on the slide, Bank of Baroda and Panesar, treated a clause which entitled a litigant to recovery of all their costs, treated that as being recovery on the indemnity basis as opposed to the standard basis. When you look at 44.3, it's a binary decision. What the judge in this case says was that treating this as an entirely novel point, it seems to me that it's not possible for a person in the position of the bank to exclude the discretion of the court. We've dealt with that. But one nevertheless starts from the position that the contractual position between the parties is that the costs will be paid on an indemnity basis. I cannot think that the words all costs mean anything other than that. Now, in that second case cited, that's a recent Court of Appeal decision. It's a judgment of Lord Justice Briggs, which is worth looking at. The judge explained that the fundamental approach for the court is, where we've got this binary decision, standard or indemnity basis, is to decide whether the wording of your clause corresponds more closely with a standard basis assessment or an indemnity basis assessment. In both standard and indemnity basis, reasonableness remains a touchstone, but on a standard basis, so does proportionality. Cost must be proportionate. And so the burden or the benefit of the doubt is resolved in favour of the paying party. That question of proportionality isn't relevant to the indemnity basis assessment, and the burden or the benefit of the doubt is resolved in favour of the receiving party. So that's the difference between the two. And in that case, the Court of Appeal agreed that all costs and expenses was more closely aligned to an indemnity basis assessment as opposed to a standard basis assessment. Now, the next two cases I think are worth touching on briefly because they show a difference of approach. Two recent High Court decisions. In the first one, Eurasian, the judge, Justice Cranston, took the view, distinguished the Court of Appeal decision of McLeish, and took the view that reasonable attorney fees was to be treated, when you were looking to enforce recovery of reasonable attorney fees, was to be treated as recovery of costs on the standard basis. That approach was then distinguished, and a different approach was taken in the more recent decision of Justice Mulder in Alafco Irish Aircraft, where the view was taken that all reasonable costs and expenses of litigation was to be treated as akin to an indemnity basis assessment. The judge in that case had reference to what Lord Justice Briggs had said in McLeish, paragraph 42, which I've said the McLeish decision is an important one. It's another one that, if you're having an argument with the other side about recovery, is worth looking at, because again, it's a helpful synthesis of the principles. But with respect, the Alafco decision is to be approved and endorsed, because you might think, well, we've included the word reasonable, inclusion of the word reasonable. Maybe that in some way meters down the recovery or lowers the standard of recovery from an indemnity basis to a standard basis. But actually, reasonableness is required in both. And that's the point that Lord Justice Briggs makes in McLeish. In an indemnity basis assessment, it still has to be shown that costs were reasonably incurred and reasonable in amount. And so, with respect to the Eurasian decision, the Alafco one is one to be approved of. And if you have a clause where the recovery is deemed in some way to be reasonable, or another wording you'll sometimes see is proper as well, it's got to be proper fees, that doesn't reduce from an indemnity basis assessment, because you'd still have to satisfy the court on an indemnity basis assessment that the costs were reasonable. Just quickly, the final point, Rule 44.5 is about assessment and the presumptions that are applied on assessment. It remains the case that the court has a discretion with regards to assessment, and it may decide to summarily assess. You'll often get that at the end of a one-day trial, or if it is a more complex assessment, it can still order detailed assessment. The contractual entitlement doesn't, again, fetter the court's discretion in that regard. Now, let's come on to the impact of the fixed cost regimes, because this is an important point. Obviously, when we're thinking fixed cost regimes, the main things we're thinking of are small claims track, which we'll come to, and fast track and intermediate track. Now, I've got on the slide the scope to Rule 45, or I've got Rule 45.1, and the scope to Part 45, which is where you find the rules on fast track and intermediate track. I've highlighted the important bit. This provision was the subject to Rule 44.5 was actually added later as an amendment to the rules. What it makes clear is that it is possible for the parties to agree between themselves, i.e. through their contract and their contractual indemnity, that the rules are not to be applied. So you see that highlighted. And what that means is, if you have a contractual provision for recovery of costs and your claim is in the fast track or in the intermediate track, you can point the judge to this provision and say that I am therefore taken out of, we submit, the fixed cost rules. This comes back to the court's discretion. Of course, it remains in the court's discretion to order otherwise because of Section 51 of the Senior Courts Act, but that doesn't change what's set out there. And you would be saying, well, the Gomba principle, the fact that the contractual entitlement is an important factor in your discretion, we say you should therefore give effect to our contractual provision. So that's what is said in respect of fast and intermediate track. In respect to the small claims track, this, I've already mentioned the Chapler-Kamari decision. This is an important one because if you've got a small claims track claim and you've got a contractual entitlement. This is the authority you'll want to be having to hand, highlighted to give to the court. Because in that case, the Court of Appeal agreed with it was a second appeal, agreed with the first appeal judge that there could be recovery beyond the scope of the Small Claims Tract fixed rules because of the contractual entitlements. So it was a landlord-tenant dispute where there'd been a dispute to do with service charges. There'd been a dispute in the Land Valuation Tribunal, which there was then a case, or it was actually in fact a case in the Small Claims Tract with the proceedings also in the LVT, but the parties agreed that their civil claim would be allocated to the Small Claims Tract. Was your claim for recovery of arrears, rent arrears and service charges. And ultimately, the key point to take away is that the court said that Rule 2714 deals with recovery of costs on the Small Claims Tract. That didn't override the contractual provision, and it didn't override the Rule 44.5. So as has been the take-home message from this talk, the key factor being the court's discretion, the fact that the matter had been allocated to the Small Claims Tract was a factor to be taken into consideration by the court when exercising its discretion, but it wasn't conclusive. And the court agreed that the contractual provision was to be given effect to. So that's the case. If you've got a Small Claims Tract hearing and you don't want to be capped at the fixed costs rules, where you've got a contractual entitlement to recover costs, that's the case to have to hand. So I can see the time. We're just coming up to 10:29. We are on our last slide. I've just perhaps slightly prematurely looked at the questions. Kenneth Tang's question was asked a couple of moments ago. Have you seen or aware of any cases where a party successfully relied on contractual costs to take them out of the fast track or intermediate track regimes? I haven't yet had to argue that point at a final trial in either of those cases. It's come to light I've had it with interlocutory applications, and the point from memory, the point was accepted there, but I think I've answered that already as to where you look. I think the provision, if we look back on this previous slide, 45.1, really subject to Rule 44.5, that's what you want to be pointing the court to. So just quickly, and then we'll wrap up, top tips. The first one, I've repeated probably already till I'm blue in the face, but don't in any way suggest that the court's hands are tied. It's always the first point you'll be making to the judge is that this is in your discretion, but this is how we say your discretion should be exercised. The second point, and this does get missed, and I think this is an important point, is make sure that you plead your contractual entitlement. The Q&A, the questions and answers about costs, which is one of the additional materials published alongside the White Book, actually deals with this specifically in question 56. And it mentions that your contractual entitlement is something to be pleaded. It was pleaded in the Chapelair case that we've referred to. It was pleaded in the Church Commissioners and Ibrahim case, which was that 97 decision which applied Golder in the landlord and tenant context. So make sure it's pleaded, because when you step back, it makes sense that it be pleaded, because essentially what you're looking to enforce, you're asking for enforcement of a contractual right akin, it's an indemnity. So if you were asking for an indemnity from a third party in a guarantee and indemnity context, you would plead it. Make sure it's pleaded when you're asking for it in the costs perspective. Point 3, this might go touch briefly on Kenneth's question about intermediate track and fast track provisions. When you're drafting your contract moving forwards, there is no harm in making it explicitly clear that the contractual entitlement is to be is recognised by the parties, etc., despite the provisions of the fixed recoverable costs regimes, or despite the provisions regarding fast track and intermediate track cases, or draft it accordingly. Make it clear if certain disputes are going to be subject to fixed costs, but other disputes aren't, then make that clear in the clause. But there's nothing wrong, now that we've got the rules laid out, with having reference to the rules, so that as and when a court comes to exercise its discretion, it can and interpret the clause, it is abundantly clear to the court that the parties, when agreeing to the contract, were aware of the rules and agreed to recovery outside of the fixed costs rules nonetheless. Then finally, point 4, don't think that what I've set out in the past half an hour or so is necessarily some way to secure recovery of 100% of your costs, because we'll know that indemnity costs are not that. The court only has 2 bases of assessment: standard basis or indemnity basis. An indemnity basis doesn't equate to 100% recovery. So when advising your clients, don't suggest that this gives them carte blanche to recover everything in full. I can see the time. We've just gone past 10:30. We'll draw things to a close there. I'll just have a quick check. There have been no other questions raised. So with that, I will end the recording. Thank you all for listening. You've got my email address there if there's anything to be picked up offline. And I have been told that the slides will be distributed alongside the recording. So have good Wednesdays, one and all. Thank you very much.